Hey, I'm Paul Rabelais, and in this video, we're going to talk about whether your estate planning attorney should be the one who keeps or stores your original last will and testament. Okay, this is it's a hot topic on a cold day, but once you sign your will, it needs to be kept in a safe place. Your executor, your heirs will need access to that original will when you die. So you got several options on where should your will be kept. And I'm talking about the original. By original, I don't necessarily mean first. I mean the will that, perhaps it was signed in blue ink as opposed to a photocopy, so you can tell it's the original. Perhaps it has some notary stamp or seal, so you can tell it's the original, because when you die, a judge wants to see the original will. They don't want to see a photocopy. The original gets filed at the courthouse. So you've got some options on where to keep your will. Some people keep it in their home in a fireproof safe or on the cabinet in their bedroom. Some people keep their original will in a safe deposit box, and when they do, perhaps they should have other family members, as a signer, having access to the box. Perhaps I know that some people give their will to their executor. Maybe it's an adult child of theirs, so that the executor will have immediate access to it when the person dies. And then some people leave their will with their estate planning attorney, and that's when I want to dive and we'll dig a little deeper on that issue. And I know I'm right here, but when the attorney keeps your will, they really keep it for one purpose only, and that is to force your survivors to feel obligated to go through that lawyer or that law firm to complete all of the probate legal services that need to be handled when you pass away. Those wills that are in that law firm or that lawyer's safe or safekeeping, those wills really guarantee the future prosperity of that lawyer or that law firm. So let me give you an example. Let's call him Willmaker. He's my age. He's 54 years old, and he gets his will done. And he goes to lawyer Joe Willkeeper at the Willkeeper law firm to get his will done. Now, Willmaker may not die. He's 54. He may not die for 40 more years. And during that time, the lawyer, Joe Willkeeper, may have retired or died or changed professions or got sick or went bankrupt or got addicted to drugs or alcohol, or quite frankly, maybe he moved out of state. Or maybe the Willkeeper law firm went out of business, or it merged into another firm, or it has new leadership 40 years later when Willmaker dies, and that causes all kinds of problems. I'll give you an example that I experienced. When I was a young lawyer, I was probably 26 years old. I worked for a sole practitioner who did estate planning. And so every couple of weeks, my job was to collect all of the wills that we had prepared and our clients had come in and signed. My job was to take all those wills every couple of weeks, go down the road to the local bank where this lawyer or this law firm had a safe deposit box, and I would just shove those new wills into that box. I'd cram them in because it was a crowded box. And so, dozens, maybe hundreds of wills were in that safe deposit box, and that was 28 years ago. Well, I only worked at that law firm for about a year, and I know that about 5 years after I left, that lawyer who I worked for no longer worked as a sole practitioner. He went to work for one of the big law firms, and that big law firm didn't have a policy where they kept their clients' wills in a safe deposit box. And then even since then, I know to this day, that lawyer has, long gone since retired. And I guess he's still alive, but he retired. So I have no idea what has happened to those wills that I crammed into that safe deposit box 28 years ago. I know some of those people have passed away. I know some of them are still alive, but I have no idea where those wills are. Okay, so, and even if the lawyer, as lawyers, we don't keep track of where all of our clients are and whether they've moved. As an estate planning lawyer, we'll deal with someone and we won't hear from them for sometimes decades. And so we can't keep track of where all of our clients are in case we need to, notify them that they need to come get their will or something like that. That just doesn't happen in an estate planning practice. We don't keep up with the whereabouts of all of our clients. So that's an issue. And there's other issues on the attorney keeping the will. Let's say Joe Willwriter, who was 54 when he did that will with Will Keeper. Let's say when Joe was 70, he worked with another lawyer and either updated or did a new will, which automatically revoked the old will. So now Joe Will Keeper has the will that he prepared at 54 and he put in his law firm's safe deposit box. But that lawyer has no idea that the client at age 70 went to another law firm and signed a new will, which automatically revoked the will that Will Keeper had prepared. So now, how long are these lawyers supposed to keep these wills that are in the law firm's safe or safe deposit box? Do they keep them for 50 years? Should they keep them for 100 years? So the lawyers, again, they have no idea whether the client updated the will, revoked the will. They have no idea whether the client died or the client moved to another state. So how long are these lawyers supposed to keep these wills? When can they throw them away? So a lot of issues there to deal with. And my thing is, when somebody who writes a will dies, the executor of that will should really feel free to be able to use the legal services of whichever lawyer or law firm they feel most comfortable with. Going through that probate is difficult. Executors need to be able to work with lawyers that that they're comfortable with. Now, maybe you get your estate planning and you get your will done and you feel like you really have a good connection with a lawyer and you want that lawyer or that law firm to be involved in your estate settlement when you die. Great. Keep your will, but tell your executor and your heirs that you'd like them to use the services of the same lawyer that prepared your estate planning program for you. That makes sense. All right, so just know that when I give you this summary, while I'm thinking about it, let me just get you to make sure you hit the subscribe button and the notification bell. That way you won't miss anything. I try to educate people every day on these important estate planning topics that they really can't get anywhere else. A thumbs up, smashing that button would be great. If you could hit the share arrow and share this with your texting friends, email friends, that would be phenomenal. All right, so just know that when lawyers make themselves available to store your original last will and testament, and they're probably going to make themselves available to do that for you for free, you might say, great, that way I don't have to worry, about keeping my original will in a safe place. The lawyer's going to do it for me. Know that when they offer that service to you, most of them do it for free, and if they charge you for it, even more, then know that they're not doing it as a service to you. They're doing it as a way to better guarantee their future prosperity, because they know that when you die, your survivors have to track down that original will. And if they look in your papers that you have at home, and in your papers say, go get the will from such and such lawyer or such and such law firm, now that lawyer knows that they got the first shot at being the probate lawyer to handle all of the probate legal services to get your estate settled. And it really shouldn't be that way, because that's when survivors, executors, heirs who don't go through this process very much, and it may be the first time they go through it, they're kind of unsophisticated. And so the lawyers who are kind of in the know, they take advantage of that unsophisticatedness, if that's a word, of your survivors to kind of trap them and make them feel like they have to use that lawyer or that law firm's services. Okay, so that's just my thoughts, and just from experience of 30 years, I really don't feel right about people leaving their will with their lawyer. There's a whole, another issue here is that perhaps if you go to a lawyer who encourages you to use a will as the mechanism for leaving your estate to your heirs, combined with them keeping the will, which requires that your survivors go back to them to do the probate, maybe there should be a whole nother discussion about whether your estate planning lawyer should help you arrange an estate legal program that could help your survivors avoid the whole probate process completely. And that's a whole nother discussion on people using living trusts or some other mechanism to eliminate the need for lawyer and court involvement when you pass away. Okay, so enough there. Stay tuned, 10 a.m. Central Time every morning, new video, more education. Again, hit the subscribe button. I would very much thank you for it. If you got some comments to contribute, especially if they're positive and they're well written and well thought out, bring them on. Love to see them. We'll see you next time.